Nnamdi Kanu's special counsel, Barrister Alo Ejimako, has asked the Attorney General of the Federation, AGF Abubakar Malami's son, to initiate the prosecution of all persons that are directly or indirectly involved in the alleged brutalization of his client during and after his rearrest and transfer from Kenya. In a letter obtained by Politics Nigeria on Monday evening, directed to Malami, Ejimako explained the need for the minister to ensure a sanction on those who initiated the controversial capture of Kanu in Kenya in June 2021. The letter, dated 20th of March 2022, elucidated how Kanu was arrested, allegedly manhandled, and brought back to Nigeria without a legal process or pronouncement from either the Kenyan court or the Nigerian court. Ejimako noted that his actions were based on the instructions of Kanu, adding that the Constitution of the Federal Republic of Nigeria 1999 is against the torture of any person placed under investigation or held in custody of any person in authority. Ejimako's letter reads, "We are solicitors to Mazi Nnamdi Kanu, on whose behalf and instruction we most respectfully bring this complaint pursuant to Section 1A and B, Section 5, Section 6 of the Anti-Torture Act 2017, and Section 174 of the Constitution of the Federal Republic of Nigeria 1999. According to the information given to us by our client, the details of this complaint are as follows. Our client entered into the Republic Kenya on his British passport on May 12, 2021, and was admitted as such at Jomo Kenyatta International Airport, Nairobi. After his admission, he settled in at a temporary location in Nairobi, Kenya. On June 19, 2021, our client drove himself to Jomo Kenyatta International Airport, Nairobi, Kenya, on a personal errand. As soon as he pulled to a stop at a parking lot and alighted from his vehicle, about 20 well-armed persons violently accosted and abducted him, handcuffed him, and blindfolded him, bundled him into a vehicle, and sped away. His abductors took him to a secret private location, not a police station, somewhere in Nairobi, Kenya, and chained him to the floor. He was neither shown a warrant of arrest or extradition, nor told why he was abducted. The abductors did not tell him who they are, but from their conversations, he summarized that they were working for the government of Nigeria and its security agencies. While chained to the floor, his abductors took turns beating and torturing him to the point that he fainted several times and was intermittently revived when they poured cold water on him. During the tortures and beatings, his abductors taunted him verbally, degraded him, and called him a separatist Igbo Jew. They also told him he would be expelled to Nigeria to face death. He was chained to the floor for 8 days and was thus forced to relieve himself of urine and excrement where he was chained. Throughout the duration of his secret captivity and torture, he was not allowed to bathe and feed, only to bland bread once a day and given non-sanitary water to drink, and except for the presence of his abductors, he was in solitary confinement the entire 8 days. Section 3 of 2 of the Anti-Torture Act states that secret detention places, solitary confinement, incommunicado, or other similar forms of detention where torture may be carried on are prohibited. The inhumane treatment, cruelty, and degradation to which the abductors subjected our client and the external and internal injuries he sustained therefrom, coupled with his pre-existing poor health, made him to live in dread, fear, and terror that he was going to die in captivity and his body disappeared. His anguish, entreaties to his abductors to get him some medication for his hypertension, heart condition, and physical injuries were inhumanely refused, and his pleas to be taken before a court or even an official police or other law enforcement facility or allowed a phone call were flatly refused. Throughout the 8-day duration of the captivity and torture of our clients, his torturers were in constant telephone conversations with and taking directives and instructions from the Nigerian High Commissioner to Kenya and other Nigerian officials. Section 2 of the Anti-Torture Act makes a person complicit in torture when it is inflicted by or at an instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Similarly, Section 8 of 2 provides that a superior military, police, or law enforcement officer or senior government official who issues an order to a lower ranking personnel to torture a victim for whatever purpose is equally liable as the principal. On the 8th day, his adopters brought him out of the house, put him in a car, drove him straight to the tarmac of Jomo Kenyatta International Airport, where they evaded Kenya immigration and forcibly bundled him into a private jet that departed the airport before noon on June 27, 2021, and arrived at Abuja, Nigeria in the early evening of same day. Throughout the duration of the flight from Nairobi to Abuja, our client's wrists and ankles were mangled so tightly that he was in extreme physical and mental pain for the entire duration of the flight. He also had the muzzle of a gun pointed to and roughly rubbing the nape of his neck throughout the duration of the flight. On arrival in Nigeria, our client was taken to and detained at the headquarters of the Nigerian Intelligence Agency (NIA) in Abuja. He spent the first night at the NIA detention facility sleeping on the floor with very bright electric bulb deliberately left on throughout the night, thus causing him extreme bodily heat, sleep deprivation, and mental anguish. Our client states that from 29 June 2021 to date, he has been subjected to solitary confinement lasting for 23 hours each day at the headquarters of the State Security Services in Abuja. Since then, our client has repeatedly requested independent medical examination by a physician of his own choice, but the requests were denied. Section 7 of the Anti-Torture Act provides that a person arrested, detained, or under custodial investigation shall have the right to be informed of his right to demand a physical and psychological examination by an independent and competent doctor of his own choice after interrogation, which shall be conducted outside the influence of the police or security force. The medical report shall include in detail the history and the findings of the physical and psychological examination and shall be attached to the custodial investigation report. Otherwise, such investigation report is deemed void. It is our considered position that the totality of what happened to our client, as enunciated above, unarguably met the definition of torture under Section 2 of the Anti-Torture Act 2017, which also states at Section 9 of 1 that a person who contravenes Section 2 of this Act commits an offense and is liable on conviction to imprisonment for a term not exceeding 25 years. Furthermore, Barrister Ejemako pleaded with Malami to take prompt measures to initiate the prosecution of all persons that were directly or indirectly culpable in the torture of Kanu, irrespective of the severity of his offense levied against him. It is our further position that regardless of the severity of the offense alleged against our client, there is absolutely no justification for the egregious torture our client endured. Section 3 of 1 of the Act provides that no exceptional circumstances whatsoever, whether a state of war or threat of war, internal political instability, or any other public emergency may be invoked as a justification for torture. In view of the foregoing, we hereby make the following prayers that, consistent with the provisions of the Anti-Torture Act 2017, the Office of the Attorney General take prompt measures to initiate the prosecution of all persons that were directly or indirectly culpable in the torture of our client. For your ease of reference, Section 5 of the Anti-Torture Act provides that 1. A person who has suffered or alleges that he has been subjected to torture shall have the right to complain to and to have his case promptly and impartially examined by a competent authority. 2. The competent authority under subsection 1 shall take steps to ensure that the complaint is protected against all ill treatment or intimidation as a consequence of his complaint or any given evidence. Nnamdi Kanu writes Malami. the Attorney General of the Federation.